This is Barry Zalma for Zalma on Insurance on YouTube. I am a lawyer presently retired from the practice of law. I spend most of my time acting as a consultant in insurance claims matters for both policyholders and for insurers. I also spend a great deal of time writing on insurance matters. In this situation, we're going to talk about construction defects and insurance, which is one of the books available from me at Amazon.com. The majority of construction defect suits and appellate decisions arise in a few litigious jurisdictions, but seem to be spreading across the country like kudzu across the South. The courts of Texas, Florida, New York, Colorado, and California have generated a great deal of law on the subject that is then applied or adopted by other states, whose courts have not seen the same volume of construction defects litigation. In my book, Construction Defects and Insurance, I have attempted to obtain and cite authorities from across North America to be as helpful as possible to the wide audience the book was designed to serve. Appendices, including forms, checklists, and samples, are provided to assist in the prosecution or defense of construction defect cases. Now, what is involved in a construction defect suit? It requires an understanding that all buildings have an expected lifespan. None except perhaps the Egyptian pyramids were designed to last eons. Yet even the pyramids in Egypt will erode to a mound of sand given enough time, wind, water, and the movement of tectonic plates. Their demise will be an expected result of age and erosion, rather than a construction defect. Venerable, well-constructed structures seldom fail because of their advanced age. Usually they are torn down and replaced with new structures before they have time to waste away. Regardless of the methods or materials used, all structures can fail before the end of their useful life. Such a failure can cause damage to people or property. The failure of a component part of a structure that causes damage to a person or property can be considered a construction defect. If the component was not installed correctly, was not appropriate for the structure, or was defectively constructed, the manufacturer, seller, and/or installer of the component may be held responsible for the damages caused. When structures fail, the damages can include, among other things, a total collapse of the structure and injury to its occupants, an inability to keep rainwater out of the structure, cracking, settling, or subsidence of concrete flatwork, cracking, settling, or tilting of walls, doors that do not fit, windows that do not operate, walls that are out of plumb, walls, doors, and windows that leak air or water, foundations that settle, crack, or subside as a result of subsidence or hydroconsolidation of the soils on which the foundation is placed, mold growth on floors, walls, and ceilings, acidic emissions from Chinese manufactured drywall, or damage to person or property of third parties. These are just some of the kinds of things that result in a construction defect suit. Construction defect claims and suits are proliferating. Courts across North America are overflowing with multi-party lawsuits brought by condominium associations, Canadian strata organizations, owners of tract homes, and commercial property owners, As construction defect claims proliferate, it has become not unlikely that most people will either pursue or defend a construction defect claim at some point in their lifetime. The dollars involved in construction defect litigation have grown exponentially. If a problem exists in a multiple unit condominium association or a housing tract, minor repairs of the defects multiply over the various units to millions of dollars. In addition, the complexity of a construction defect suit usually results in hundreds of hours of work for attorneys and the need for separate counsel for each party defendant, like the owner, architect, general contractor, and each subcontractor. The settlements and judgments are often extremely large, and attorney's fees generated in such cases with multiple parties are high and encourage lawyers to file suit, and those who succeed also do wonders for the defense bar, who are able to earn a great deal of money by defending the various parties. The targets of construction defect litigation are many and varied. Construction defect claims can be presented to any of the following: property owners, builders and contractors, buyers, sellers, part manufacturers, suppliers of material used in original construction or repairs, designers, property managers, architects, engineers, geotechnical engineers and geologists, surveyors, subcontractors, real estate inspectors, real estate brokers or salespeople, real estate investors or developers, structural engineers, and just about anybody who has any interest in the operation or construction of a building. And when the litigation goes on, because there are so many of these different potential responsible parties, lawsuits will name as many as 20 different defendants. And therefore, one lawyer for each of the 20 defendants makes a deposition of a plumber fairly lengthy. I've sat into such depositions where by the time they get down to the man whose name starts with the letter Z, I merely introduce myself and say, everyone's asked the same questions. I just wanted you to know I was here. So what is the basis of a construction defect claim or suit? To begin with, it's negligence. Negligence has the same definitions, regardless of the state where it is alleged. It has been defined as a legal duty owed to the plaintiff by the defendant, a breach of that duty, and an actual injury to the plaintiff, a showing that the breach was a proximate cause of the injury. A breach of duty exists when it is foreseeable that one's conduct may likely injure the person to whom the duty is owed. The California Supreme Court upheld a judgment for property damage caused by negligent residential construction in a case called Sabella versus Whistler back in 1963. The defendant had built a house and offered it for sale to the general public. As it turned out, the defendant's negligent preparation of the lot, in combination with a subcontractor's careless plumbing work, later caused leaks, subsidence, and damage to the house. The purchaser sued for negligence. The builder, arguing unsuccessfully against the imposition of tort liability, held that the liability of a contractor should be determined by the consideration and weighing of the various factors bearing upon liability. It was held the builder was responsible for the ensuing damage. The Nevada Supreme Court, in answer to a question posed by a federal district court, concluded that in a commercial property construction defect action in which the plaintiffs seek to recover purely economic losses through negligence-based claims, the economic loss doctrine applied to bar such claims against design professionals who had provided professional services in the commercial property development or improvement process. That was a case called Taric Consultants versus Mandalay. Formally, once a builder had completed a structure and the purchaser had accepted it, the builder was not liable to a third party for damages suffered because of the work's condition, even if the builder was negligent. The purchaser had remedies against the builder in contract and warranty. Injured third parties had no clear remedy until the Supreme Court, following the trend that began with McPherson versus Buick Motor Company back in 1916, qualified the general rule exonerating manufacturers from third-party claims with an exception applicable whenever the nature of a manufactured thing is such that it is reasonably certain to place life and limb in peril when negligently made. The Supreme Court had already held that the manufacturers of defective ladders, elevators, and tires could be liable to persons not in contractual privity with them, yet foreseeably injured by their products. The Supreme Court had no trouble applying the same rule to someone responsible for a defective rail in a case called Hale versus DePauli. On the other hand, in Arizona, the Court of Appeal in Karstens versus City of Phoenix refused to allow plaintiffs to sue the building inspectors for negligence because there was no bodily injury or property damage suffered. My book, Construction Defects and Insurance, consists of 8 separate volumes in detail covering every possible solution and situation in which a construction defect may occur and may cause damage to third parties. It is available from my website, Zelma.com, under the link for Zelma's Insurance Claims Library, and it is available on Amazon.com at very reasonable prices for both a Kindle version or a paperback version of the 8 volumes. You can find them at Amazon.com by simply putting into the search bar my name, Barry Zelma, and construction. That should get you the books. Thank you for listening.